Hey guys, it's Amy. Today we're going to be looking at the Groves trial. So let's start off with the opening statements. Here we go.
Each side will address you once during opening statements, with the state going first. Is the state ready to proceed with opening statements?
We are, Your Honor.
Is the defense ready, Ms. Scott?
We are ready, thank you.
Mr. Stratton?
Yes, sir.
The state may address the jury.
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen of the jury, good morning. Again, my name is Julie Hutchinson, and I, along with prosecuting attorney Shane Tiemann, represent the state of Ohio. Before we discuss what it is that the state must prove and what we believe the evidence will be, I too want to thank you for your service. The service that you are about to complete here on behalf of your community is very vital to our American justice system. And each of us understand that each of you have other obligations you are putting aside to be here with us this week. So thank you. I also want to apologize to you in advance. The case you're about to hear is a difficult case. You're going to see, hear, and learn things that you cannot unsee, unhear, or unlearn. And for that, I'm sorry. Having said that, let's discuss what the charges are in this case. The defendants, Daniel and Jessica Groves, are charged with 11 felony charges. His Honor, Judge Kuhn will instruct you on the law that you are to follow throughout this trial. If something I say differs from what something he says, you are to follow His Honor's instructions. You heard in voir dire the phrase, being in cahoots with someone. And you also heard in Ohio that the legal term for that is complicity. His Honor may instruct you that the defendant or defendants can be found guilty of the offense charged as a principal offender, in other words, the person who committed that crime, but also can be found guilty of that principal offense in complicity. In other words, they don't have to be the person who actually committed the crime, but complicit to that person or in cahoots with that person. You may be further instructed that complicity means aided or abetted. Sorry about that. Technology is great when it works. And you may also be instructed that aiding and abetting includes supporting, assisting, cooperating with, advising, inciting another to commit a crime. Complicity also includes conspiring with another person to commit a crime. State of Ohio versus Daniel Groves and State of Ohio versus Jessica Groves charges each defendant with the following felony charges. Aggravated murder. Requires the state of Ohio to prove beyond a reasonable doubt that the defendants did or were complicit to purposely causing the death of baby Dylan, who was under 13 years of age at the time of the offense. Defendants are charged in count 2 with murder, which requires the state of Ohio to prove that the defendants did or were complicit to knowingly causing the death of baby Dylan as a proximate result of committing or attempting to commit a felony offense of violence that is a felony of the first or second degree. In count 3, the defendants are charged with kidnapping. Kidnapping requires the state of Ohio to prove that the defendants did or were complicit to, by force, threat, or deception, or in the case of a victim under 13 by any means, remove baby Dylan from the place where he was found or restrain his liberty for the purpose of hindering, impeding, or obstructing a function of the government. Count 4, child endangering, requires the state of Ohio to prove that the defendants did or were complicit to, as a parent, guardian, custodian, person having custody or control or in loco parentis of a child under the age of 18 create a substantial risk of health or safety to baby Dylan by violating a duty of care, protection, or support, and that violation resulted in serious physical harm. Count 5, the defendants are charged with tampering with evidence, and that requires the state of Ohio to prove that the defendants did or were complicit in knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such investigation. Count 6 charges the defendants with interference with custody and requires the state of Ohio to prove that the defendants did or were complicit to, knowing that he or she had no privilege to do so or being reckless in that regard, entice, keep, or harbor baby Dylan from a parent, guardian, or custodian of a child under the age of 18, and that baby Dylan suffered serious physical harm as a result of that violation. Count 7, gross abuse of a corpse, requires the state of Ohio to prove that the defendant did or was complicit to treating baby Dylan's body in a way that would outrage reasonable community sensibilities. The remaining counts 8, 9, 10, and 11, are counts of felonious assault, and they require the state of Ohio to prove that the defendants did or were complicit to knowingly causing serious physical harm to baby Dylan. Having heard the charges you are to consider, let's turn to the evidence and testimony that the state of Ohio believes will be presented in the coming week. The evidence will be that on January 10th, 2019, in the early morning hours, the defendants Daniel Groves and Jessica Groves arrived by self-transport at the emergency department of Southern Ohio Medical Center here in Scioto County, Ohio. Several hospital employees will testify here. They will testify that for Jessica, labor was nearly complete upon arrival, as she was dilated 9.5 out of 10 centimeters. They will testify that Jessica Groves refused to answer any questions and that a urine sample had to be taken by straight catheter. The testimony will be the hospital staff administered no pain medications to Jessica Groves for several reasons. There were no medical records of prenatal care. Jessica appeared to be under the influence but refused to answer any questions about what substances she may have taken. And not giving medications enabled the staff at the hospital to determine what had been ingested pre-admission so that they could care for baby Dylan once he was born. It will be claimed that Jessica, for some period, lengthy period, had no prenatal care because she did not know she was pregnant. However, the evidence will show that she's had a prior pregnancy and that she was once a licensed LPN. Baby Dylan was delivered within approximately 30 minutes, and the testimony will be that that delivery was uneventful. No complications in that delivery. Not long after birth, baby Dylan was taken to the nursery and put on oxygen because he was born early and needed support. The testimony will be that neither parent accompanied that baby to the nursery. At some point, urine was also collected from baby Dylan for drug screening purposes, and both Jessica Groves and baby Dylan had positive drug screens there at the hospital. Within 12 hours, baby Dylan begins to exhibit symptoms of drug withdrawal. As a result of that, the hospital then notified Scioto County Children's Services, and baby Dylan was kept in the nursery for 5 days, awaiting a discharge plan that the hospital and Children's Services could agree was safe. Initially, Children's Services believed that Daniel Groves was employed with Rural King and that he could submit to a clean urine test. A safety plan was discussed wherein baby Dylan would be placed with Daniel Groves, that Jessica Groves would not live in the home, and that her contact with the children in the home would be supervised by Daniel Groves. Children's Services was going to require Jessica to complete a drug assessment and to undergo treatment and be compliant with that treatment. There was to be weekly contact between baby Dylan and Children's Services. However, the hospital would not agree to discharge baby Dylan under that safety plan. Prior to the release of baby Dylan from the hospital, his umbilical cord was sent off for testing, and the results were returned. Baby Dylan's U cord, or umbilical cord, showed positive for methamphetamine, amphetamine, fentanyl, and opiates, including morphine. On January 15th, 2019, Andrea Bowling became baby Dylan's foster mother as she picked him up from the hospital. On January 16th, 2019, Scioto County Children's Services awarded emergency custody of baby Dylan to Children's Services. During the time that foster mother Andrea Bowling had baby Dylan, he was seen twice by a pediatrician named Dr. Ali. His medical records indicate, and Dr. Ali will testify, that he was free from injury and progressing well, with the exception of some drug withdrawals. Baby Dylan lived with Andrea until January 28th, 2019, when Children's Services decided to place the baby back with Daniel Groves under circumstances similar to what was previously discussed. Evidence will show that Jessica was assessed by Mahajan Therapeutics for drug treatment on January 18th, 2019, and that she was compliant with treatment for less than 3 weeks. The defendants were compliant once the baby was placed back with them with pediatrician appointments for less than 1 month. However, from those 2 appointments, the evidence will show that baby Dylan again was injury-free and progressing well. The defendants also were not compliant with Children's Services. Evidence will show that between February 4th and February 25th, Children's Services was making multiple attempts to contact this family, to no avail. Children's Services even went to the school of the 14-year-old sibling to attempt to get a message to the parents. Finally, on February 25th, Children's Services was successful in making contact with the family at their residence at 2241 Mount Hope Road, Otway, Ohio, here in Scioto County. From that date, February 25th, to March 28th, again, the defendants were not compliant with Children's Services contact. On March 28th, Children's Services again made contact, successful contact, with the family at that Mount Hope address. Baby Dylan was wearing a long-sleeved onesie, and he did not appear to have any visible injuries. It was the last time baby Dylan was known to be alive. No calls for medical assistance for baby Dylan were ever made for that residence. That's going to be the evidence. All through April and May, Children's Services repeatedly tries to make contact. Children's Services eventually calls Rural King to attempt to make contact with Daniel Groves, and they're informed that Mr. Groves had not worked there since mid-2018. Deputies of the Scioto County Sheriff's Office attempted to make contact. Captain Murphy and Chief Miller from the Sheriff's Office attempt to make contact. They see the defendants on the roadway near their home and attempt to stop them, and a pursuit ensues, and the four-wheeler they are on flees off the roadway into the woods. Juvenile court sent an employee to make contact. Finally, the Sheriff's Office obtains a search warrant for that Mount Hope residence. And on June 10th, 2019, several members of the Scioto County Sheriff's Department, the Southern Ohio Drug Task Force, and the Ohio State Highway Patrol surround the residence on Mount Hope Road, demanding that Jessica and Daniel surrender. Within about 30 minutes, Jessica Groves appears at the front door, and the testimony will be that she's belligerent. Hours later, a robot is deployed inside the residence to locate Daniel Groves, who is not coming out at the demands of law enforcement. Both were transported to the Scioto County Sheriff's Department for interrogation by Detective Conkle. You will hear that Jessica Groves maintains that Children's Services has come and taken her baby. Evidence will be that Daniel Groves is dope sick in there during that interview, rolling around in the floor. Evidence will also be that he tells several stories, starting with Children's Services came and took the baby. But eventually, Daniel Groves admits that baby Dylan is dead. On June 11th, 2019, Daniel agreed to take Detective Conkle to Dylan's body. Nothing was found. On June 12th, the evidence will be that these two defendants were placed in the room together and began whispering amongst each other. The things they're saying indicate to Detective Conkle that she's been misled about where this baby's body might be. After further interrogation, Daniel Groves again agrees to take Detective Conkle to baby Dylan's body. Eventually, Daniel Groves leads the sheriff's office to a spring-fed well, 40-foot well, in the middle of a hayfield. Members of the local fire department respond to assist, and the fire department could not make it through in the truck, so they used a brush truck to get to that location. They attempted to pump water from the well. However, the pump was only successful in removing about 10 feet of the water. After that, they went back to the fire truck and they retrieved parts of an extraction kit. And with a gold metal hook, a strap, and some cord, they for 3 hours fished around in this water before they finally hooked what they thought might be the container that contained baby Dylan's body. It took several men to pull the container to the surface. Evidence will show that the container consisted of these two metal crates, or these two plastic milk crates, chained together, zip-tied, and wire-tied. It was weighted down with several rocks and a round metal object around Dylan's body. The container was loaded undisturbed for coroner's transport to the Montgomery County Coroner's Office. The coroner will testify that baby Dylan's death was the result of homicidal violence. Dr. Brown will testify that baby Dylan had 2 skull fractures, 2 rib fractures, upper arm fractures, lower arm fractures, and lower leg fractures. She will testify that some fractures showed signs of healing and others did not, and she'll explain to you what that means. The testimony will also be that baby Dylan again tested positive for methamphetamines and amphetamines. Ladies and gentlemen of the jury, by the close of this case, I submit to you that you will have proof beyond a reasonable doubt that each of these defendants is guilty of each crime that they're charged with. And at that time, I will ask you to return a verdict of guilty as to each defendant and as to each count. Again, I thank you for your time.
Thank you, Ms. Hutchinson. Scott, Mr. Stratton.
Mr. Stratton.
Mr. Stratton will address the jury.
If it pleases the court, the state, Attorney Scott, ladies and gentlemen of the jury. Let me begin the story of this tragedy. As most of you are aware, through the news or personal experience, our community, Portsmouth and Sauter County, has been and still is ground zero for this terrible drug problem. We hear regularly about overdoses and crimes directly related to drugs. It has taken a foothold here and has devastated our friends, our family, and our whole community. It is no respecter of age, status, or wealth. This scourge of our modern society turns spouses against spouses, siblings against siblings, grandparents against grandchildren, and breaks the bonds of family. Grandparents are raising grandchildren, and in some cases, great-grandparents are raising great-grandchildren. There are so many people trying to reverse and correct this problem. There has been this upswell in our community of people that have said enough is enough. We're going to change and come back. We will win this fight, make our home a better place. But the first step in winning this fight is for individuals that have been led down this path to take personal responsibility for their crimes and their sins. And that starts right here, right now. My client, Jessica Groves, was and still is a drug addict. There is no doubt about that fact. She, and she alone, caused the injuries to Dylan Groves, which led to his death. She murdered Dylan Groves. She will testify that she murdered Dylan Groves. She will testify to the injuries that she caused to Dylan Groves. The 2-inch fracture on the skull, the 1-inch fracture on the skull, the 1/2-inch laceration on the left arm, fracture of the left humerus, fracture of the left radius and ulna, red contusion on the right side of the chest, healed rib fractures, and the drugs in baby Dylan's system. These are the injuries caused to Dylan Groves by Jessica Groves. Finally, you might ask, why put everybody through this ordeal? Why put everybody through this trauma? The answer is because she's going to do the right thing right now. And that right thing is to take personal responsibility for her crimes and sins. And that right thing also is to protect and defend an innocent man. Daniel Groves had nothing to do with the death of Dylan Groves and did not cause these injuries. He was foolishly unaware of these injuries. And I say foolishly because hindsight's always 20/20. And sometimes you're oblivious to what's going on. This is especially true from someone you have known for 20 years and that you have loved. Dylan Groves died on March 28th, and Daniel found him unresponsive. Once he found him, panic and confusion set in. And with that panic and confusion came poor decisions. That leads us all to here today. Did he help hide the body? Yes. Did he suggest the well? Yes, he knew where this well was. Did he help craft a coffin and preserve Dylan? Yes, he did. But that is all he did. Jessica Groves is the person responsible for the death of Dylan Groves. She is here in front of you today, taking personal responsibility for her crimes and her sins. Thank you, Your Honor.
Thank you, Mr. Stratton. Ms. Scott, you may address the jury.
Thank you, Your Honor. Ladies and gentlemen of the jury, good morning. And as Ms. Hutchinson spoke to you all today, we definitely thank you for your service here in this matter, your time and attention in this matter. And as I talked to you a little bit yesterday, what I believe is an honor to participate in this system that is very unique to our country. And we do appreciate the full attention that I know that you will give to the seriousness of this case. And obviously it's a very upsetting topic and very disturbing topic that we do and that Ms. Hutchinson has already apologized to you that we're going to have to discuss with you all over the next several days. I'm not sure if you were expecting to hear what Mr. Stratton has already spoken to you about, but obviously, ladies and gentlemen, we would argue and support that position in this matter, that Ms. Groves is the principal perpetrator in this matter. And that is in a position that has actually been held by the state in this case since this case was arraigned right here in this courtroom. In fact, Ms. Hutchinson actually called Jessica Groves.
Objection, Your Honor. May we approach the bench?
Any opening statements, whether offered by the prosecution or the defense, are not evidence, but they are merely designed to assist you in following the evidence in this case.
Thank you, Your Honor. As I was saying, ladies and gentlemen of the jury, even the state in this case, and Ms. Hutchinson, as far as that arraignment in this matter, when this case was right here in this court for the very first time, actually labeled Ms. Groves principal perpetrator. That will be the position that Mr. Groves will hold. That is the position that actually Jessica Groves is going to own in this matter, as you've heard from the opening statement. You also heard Mr. Tiemann yesterday in his voir dire and questioning of the jury. He said that they have the burden, they have the standard that they have to prove, and I will ask you that you hold them to that standard for each and every case, each and every charge in this matter. They are the ones that have to prove each and every element. They have to provide you evidence, facts that support each and every one of those charges that my client is facing before you. And I would ask that you hold them to that burden, hold them to that standard, hold them to that beyond a reasonable doubt that he spoke to you about yesterday, that the judge is going to fully instruct you on. We're going to ask that you make sure prior to rendering your verdict that you either have the facts that support that case or you do not have the facts to support that case, and you weigh that against beyond a reasonable doubt. We would ask that you would listen to all the evidence, listen to all the testimony before you make up your mind in this case. And I'm sure this case is going to be very emotional, this is going to be very taxing, and it's going to anger you. If it doesn't, I'll be very surprised. But I want to ask you and to remind you to render a fair and a just verdict here, one that matches the law that you will be instructed on. Ladies and gentlemen, you heard my co-counsel in this matter, Mr. Stratton, who's representing Mrs. Groves, talk about how my client participated in helping her dispose of the body. You heard Ms. Hutchinson get up here and tell you that my client actually, after some misconception, that he did lead the law enforcement agency to the recovery of Dylan's body. But that's it, ladies and gentlemen. He only helped dispose of the body. He did eventually cooperate with the police because he couldn't lie about it anymore. And I believe that you will hear law enforcement come in and talk to you about that. He led them to where Dylan had been placed. He did not cause his death. He never kidnapped him. He never caused his death. He never endangered him. He never interfered with custody. He never caused harm to this child. He cannot be the source of felonious assault that he has also been charged with. And that's what I want you to listen for. Either that's going to be proven or not proven throughout this case. And it is our position that that will not be proven by the state. That will be accounted for by the actions of Jessica Groves, and she is going to own all of those actions, and she will tell you in her own words, or we anticipate her telling you in her own words, how, whether you call it my client was blind, whether you call it that he was foolishly unaware, as Mr. Stratton pointed out, he may have been, ladies and gentlemen, but he had no knowledge, he had no participation, and he was not the source of the injuries that resulted in Dylan's death. Once again, listen to all of the evidence, listen to the testimony before coming to your conclusion, and render a fair and just verdict in this matter. Thank you all.
Thank you, Ms. Scott.
Okay, that's going to do it for opening statements. Up next, we will have the first day of the trial. I hope you guys will please like, share, subscribe, and of course comment. Let me know what you think about what's going on with this case. All right, thanks a lot, guys. Bye.